Another notebook as well. Further hearing an appeal of Target Group Limited against Commission for His Majesty's Revenue and Customs.
Well, I'm afraid I'm having a senior moment this morning and have left my laptop upstairs. But you can, provided we're not looking at an authority right away, you can proceed.
Well, my Lord, we're looking at your own words in a particular case, which I forgot to mention yesterday. The case is loyalty management.
Oh, yes.
And it appears in the electronic bundle at the physical bundle at 44, electronic at 1410. The words in question are at page 1429. The facts of the case are very different from our own case. It was a case to do with the directionality of supplies and reward goods and etc. And it had indeed gone to and come back from the European Court at this stage. That's all background. The foreground, if I may just, particularly in the light of Card Point yesterday, just remind my Lord and the Court what was said at para 68 on page 1429, and I quote, "It is also important to bear in mind that decisions about the application of the VAT system are highly dependent upon the factual situations involved. A small modification of the facts can render the legal solution in one case inapplicable to another." My Lord went on, "I would therefore hesitate to treat the judgments in red row as laying down a universal rule which will necessarily determine the identity of the recipient of the supply in all cases. Given the diversity of commercial operations, it may not be possible to give exhaustive guidance on how to approach the problem correctly in all cases." End of quote. And I would simply and respectfully invite the Court to bear that in mind, albeit that we're looking at a different question from what the Court saw yesterday, and indeed from what it is about to see today on the debt collection point. Clearly, there is room for movement, and detail matters. That was point number one. Point number two, a reflection overnight, an equally short point, just to take the Court back briefly to the discussion about MOM and ATP. I am guilty of having overemphasized the English law dimension, mindful of the exchanges with the Court. I stand by what I said, and the Court indicated its provisional thoughts. What ultimately matters, of course, is the European law dimension, and the European law dimension in the sense that ATP and the other cases remind us that in certain circumstances where the making of entries particularly defines a changed debtor-creditor situation, that will be treated of itself, all else being equal, as an event which can trigger the exemption. All else being equal, obviously, are key words. What I have in mind is the fact that another part of the self-same exemption, a part which we don't seek to access, of course, is the operation of current and deposit accounts. That's abandoned as a point, but it still sits in the legislation, indicating that this is legislation, part of which does recognize as the subject of an exempt supply the making of account entries, because the operation of accounts ultimately turns on the making of account entries. I don't pretend this is a big point in my favor, but a combination of ATP recognizing that the payments and transfers part of the exemption will, for example, in that situation, be satisfied by the making of account entries, with the other part, which I've just mentioned, not before you, but certainly in the legislation, namely the operation of bank accounts, may well give the making of account entries a higher status, fiscal status, than perhaps the English law analysis yesterday admits. final footnote before I move on to debt collection, having dipped briefly into the financial ombudsman's guidance on mortgage overpayment last night, it's all very complicated. And it is indeed, as I think the court was indicating, dependent on a human judgment as to what was known by whom and when. So that's the second point dealt with. And the third point brings us to debt collection. And the first words spoken on the subject, actually, before I say that, I should say that debt collection reasoning in the first tier is to be found, not proposing that it be opened at this stage, because it is a pure point of law, but the debt collection reasoning is to be found between paras 94 on page 267 and 108 on 270. And essentially the tribunal identified the fact that there were debts, they do get settled, there was no intervening phase in the analysis, therefore it's a debt collection process, therefore it's taxable. The first words spoken on the subject by the European Court were spoken in MKG. The relevant page is of the electronic bundle is 635. That's the first page of the case. Two initial observations, 635 tab 7 in the physical bundle. Two initial observations. This was a case which concerned factoring, true factoring, i.e. without recourse, and quasi-factoring with recourse. Nothing turned on that distinction. So it was a very, very specific case. Advocate General Jacobs took part, and the question in the case was, given that only the English and Swedish versions of 13BD3 mentioned factoring, was factoring nonetheless to be treated as taxable? So this is wording which is no longer in the European legislation. And the answer was yes, it should be treated as taxable. And the reasoning of the court on the point was short and clear. If we look at 641, page 641, just briefly, at the end of Advocate General Jacobs' comments, he says at 33, on page 641, the explicit reference to factoring in the English and Swedish language versions of the final clause of Article 13BD3 provides strong support for the conclusion that true factoring falls within the exclusion to the exemption laid down by that person, especially given that the more general formulations of the exclusion adopted in other language versions wouldn't appear to be incompatible with an interpretation which encompassed true factoring. And he concludes at 35, or he recommends that it be placed outside the exemption. The court I should have said there is another point as to whether a factor is engaged in economic activity at all. That does not concern the court, and it took up the lion's share of this decision. So I'm jumping from the end of the Advocate General to the end of the judgment, which in material part starts or is on page 651. Page 651. The court at the top of that page observes at 74 there are these language divergences. It then makes the point at 75 that exceptions to the exemption are to be broadly construed, which we've seen many times. And at 77, it takes the view that, and I quote, second, in the other language versions, the term debt collection must be interpreted as encompassing all forms of factoring. In accordance with its objective character, the essential aim of factoring is the recovery and collection of debts owed to a third party. Therefore, factoring must be regarded as constituting merely a variant of the more general concept of debt collection, whatever the manner in which it is carried out. 78. Moreover, the term debt collection refers to clearly circumscribed financial transactions designed to obtain payment of a pecuniary debt, which are clearly different in nature from the exemptions set out in the first part of Article 13bd3 of the 6th Directive. And they conclude, therefore, its exception. And 78 is pretty much the entirety of my argument on this point, that in order to be excluded, it has to be, quote, a clearly circumscribed financial transaction. I realise that is simply replacing a broader question with a narrower question, but it's more helpful than that in this sense, that we respectfully question whether we should be strictly describing this as a carve-out rather than the erection of a fence between two importantly different activities. In this sense, that debt collection, with or without the added words factoring, clearly can be described as a clearly circumscribed financial transaction. It's somewhat elephantine in the sense that you think you know it when you see it, but it may not be that easy to define. But the analysis, very short analysis, would be as follows. We know that solicitors, enforcers, bailiffs, and others, we know that that world is clearly a world of debt collection. We know that factors are supplying a service in which they buy the debt and they will collect it in, admittedly for their own benefit, but that's what they do. And that, and perhaps some other examples which I can't think of, could coalesce to form a clearly circumscribed financial class of transactions. We also know that every time there is, not every time, but most of the time when there is a movement of money through the banking system, a debt will thereby be settled. Not all the time, because one makes gratuitous payments, of course. One moves money for one's own benefit. But one knows that an unquantifiably large subset of money movement through the banking system will involve the settlement of a debt. And the argument is very simple. It's inconceivable that one can identify a policy objective which is satisfied by treating half of those transactions as taxable. I've moved the argument to policy objective, A, because one can't think of any particular advantage. For example, velvet and steel. What's the difference between the bank that pushes the money and the bank that pulls the money? In velvet and steel terms, nothing as far as one can identify. If one thinks in terms of the disruption the fiscal disruption in the market, there would have to be a different tax treatment at two ends of the same transaction, with a bank that is accustomed to pushing money having a better VAT outcome, because it can reclaim its VAT on pushing out money, for example, responding to a direct debit demand. It pushes the money out in obedience to the demand. Forgive me, I got it the wrong way around. The bank that pushes out the money would be exempt still, but the bank that receives the money, apologies, would, on this version, be taxable. Yet we know as money passes through the system via those BACS messages, there are just various account entries being made. And of course, if there were a different setting, a different relationship between the receiving bank and its customer from the sending bank and its customer, one might be able to construct a rationale for two different tax treatments. But it's just a banking relationship. It's just, in exemption terms, the operation of bank accounts. And of course, it would also potentially require banks to inquire whether incoming money is simply a transfer from one's account in one bank to another, or whether a debt is being settled. So, just very briefly, those points, both in terms of policy, Velvet and Steel, competition between banks essentially doing the same things, and practicality. We submit are overwhelmingly in favour of excluding what my clients do in this case from the exclusion. What I haven't articulated is my clients in this case service a non-clearing bank, Shawbrook, that happens also to be a mortgage lender. But everything I've said would apply equally to a clearer who is also a mortgage lender. So everything I've said would apply to the major clearing banks in the system. So that's essentially my submission on the issue. May I simply draw to your attention, I'm very mindful of time, the next case in the story is the AXA case in 2010, which was at the European Court. That's electronic page 652. I can't recall if the court's been taken to, I think it may have been taken indirectly to page 660, which is that there's no Advocate General, which is that part of the judgment which concludes that notwithstanding MKG, so notwithstanding the sort of submissions I've just made, based on the principle we say can be derived from MKG, the DEN plan, which was a variant of the DPAS plan, but all the supplies were made to the dentist, they conclude there that it is covered by the exclusion, and without reading anything, at 29 they refer to MKG, and at 30 the imperative to interpret broadly. At 31 they focus on debt collecting and factoring, and with very little policy analysis at 32 they simply say it follows that it's covered by the exclusion. So that's the limit of the reasoning there. Then DPAS, and obviously that is a decision which, if it had been left at that point, would be binding, but it hasn't been left at that point, and that was a case where all the supplies were made to the dentist, and we're back to matters of detail, and DPAS comes along with a slightly different scenario, albeit one in which the court was sceptical that there had actually been any real changes involved in the DPAS rejigging, so that the supplies in part were made to the patient. So if one comes to DPAS at 745, tab 14, the Advocate General, the court is relatively silent about this issue. The Advocate General at page 759, paras 59 to 63, grapples with the issue, and in a passage which is implicitly but not expressly accepted by the court, raises at 61 the question of whether the court in AXA really did intend to broaden the scope of the exemption. He speculates at 62 that it wasn't their intention, and he focuses on the fact that the phrase "as a matter of principle" was used, he refers at 64 to the traditional case law being upheld. So although there isn't direct criticism as such, it's clear from his proposal, his opinion, and the court's decision that the tectonic plates have moved as between AXA and DPAS in the way that the court saw in detail yesterday. Before that, so out of the chronological order, and I apologise, the AXA case came back to the UK, to the Court of Appeal, and this appears at page 924. So back to 2011, apologise, the chronology is slightly unsatisfactory, but the taxpayer was arguing that because the factoring debt collection exemption hadn't been transposed into UK law, notwithstanding that the taxpayer had lost in Europe, it should still win in the UK. The Court of Appeal held no, although we didn't, in the UK, transpose the words factoring, etc., or debt collection rather, into our provisions, nonetheless, it's implicit, and that is what Her Ladyship, Lady Justice Arden, she then was, at 941, at para 49 and following, is addressing. So I won't read 49 and 50 because that's just the basis for what follows. At 51, if I may, so I'm reading at the bottom of 941, as to the effect of the ruling in the present case, in my judgment, it is clear that the Court of Justice concluded that the words debt collection in the carve-out have a meaning capable of being applied to transactions concerning payments within the exemption in 13BD3. It then has to be decided whether the actual transaction in question falls within the exemption or the carve-out, and this will depend on its precise facts. If it falls within the exemption, it will fall outside the carve-out, and vice versa. The Court of Justice doesn't define the purpose of the exemption. It is unnecessary to decide on this appeal what the full scope of the exemption might be. However, for the purposes of this judgment, it may hypothetically be taken to be normal retail banking activities. And indeed, that is one way of reading paras 24 to 27 of the judgment of the Court of Justice in Nordea. On that hypothesis, the carve-out takes out of the scope of the exemption any separate supply of services which is more properly regarded as a service of debt collection. And she then goes on to say what she says at 52, that I just read the first sentence. In my judgment, it's also evident that the Court of Justice understood that the service in the present case was purely payment handling and not debt collection in the usual sense of the word. See, for example, certain paragraphs, etc. I think I will break there. So Her Ladyship indicates that there is a no man's land between what is obviously debt collection and what is obviously payments and transfers. She, for my purposes, her statement, which I commend to the court, that normal retail banking transactions are outside the exclusion, that has great resonance with the sphere of financial transactions point that I mentioned yesterday. Thus, if, and to the extent the court is with us in its final view on the applicability of the exemption, it is likely that if that occurs, the court will have distinguished the dentistry, the mobile phone, and the cinema type cases. And it's in one of those that the European Court said what it said in the AXA case. And in my submission, if the court is persuaded to make that distinction, then it should be plain sailing for the court then to conclude that there is no policy reason, having concluded that my clients are in a different sector, as it were, why this tailpiece should nonetheless apply. So a lot turns, we say, on how, if you don't reach the exemption conclusion, it doesn't arise, but a lot turns on how you provisionally, at any rate, reach the exemption conclusion. So that's my submission on the debt collection point. And I'm eating into my lady friend's time, and I apologize to him.
Can I just clarify? So you accept that the DPAS case, insofar as paragraph 28 of AXA in the CJU had, by jumping to the carve-out or fence or whatever, implied that it fell within the exemption unless it was carved out, that was then corrected in DPAS.
Yes, well, I
the
assert
court
that.
and the Advocate General said, no, that's not what they meant.
Yes, I assert that, my lady. And then
So just so pursuing the point, so the proper characterisation of a transaction is that it either falls within one category or the other. Is that right?
yes, I do.
It's not, so if it's properly characterised as falling within the first part of B3, then the question of debt collection just doesn't arise.
Well, that's precisely why I've erected a fence rather than gone with the carve-out. Because if you didn't have that, then you would inevitably, for example, have solicitors who are involved in conveyancing, moving money around, saying, well, this bit of what we do is exempt, and the answer there will be no. It's a wider package of conveyancing services. You collected in the debt at the end, but you're in the exclusion. It's just clarifying.
Yeah, so the tailpiece doesn't function as an exception. Yeah.
That's my submission. Then finally, so the fifth point, which is somewhat in the air, but it has to be dealt with. This is the management of credit point. I have to invite the court one last time to look at the exemption, a big picture look. That it's on page 577 of the bundle, if that's where it's being seen. And the point, as I understand it, is that in 13BD1, it says the granting and negotiation of credit and the management of credit by the person granting it. And that concept of the management of credit by the person granting it is repeated, mutatis mutandis, in 2, and that there was in the past a broader exemption which also exempted management of credit, generally not restricting it to management of credit by the person granting it. So it's a ghostly presence in the exemption, and it's suggested that the court, in construing 13BD3, should bear that in mind in some fashion in its deliberations. And if I can make my general points and then just show you Abby, and then I will have concluded. My first point is it's difficult enough to apply and to construe these somewhat laconic exemptions within the four corners of each exemption. So 13BD3 has been occupying us and will have occupied the court for 2 days of argument, without then asking whether and how, if at all, that could be fitted with other of the 13BD exemptions, each of which has its own agenda, its own policy objective, and has been the subject, no doubt, of political debate. That's unworkable, because which of these exemptions, I ask rhetorically, is the lead exemption into line with which all the others have to fall? Or is some form of synthesis to be required, just in case that there is an overlap. It's completely unworkable, and one must remind oneself that this is a self-assessed tax. So the banking community, the payment services community, hopefully have to be able to work out for themselves what the position is. That would be difficult enough, that you would have to constantly think about all the other exemptions. But then to have to, third layer, to have to think about what isn't in, but was once in an earlier exemption. So to have to think about the fact that 13BD 1 used to have a broader management exception is becoming impossible. One might even, with temerity of course, suggest that it might even be a challenge at the judicial level to work out the significance of a now no longer extant omission in a different exemption. The fourth point is, what does the word management mean anyway? The word management appears 4 times in 13BD. It appears in 1, in 2, in 5, and in 6. And the European Court has told us that in 5 and in 6, it has a radically different meaning as between those two. And that's the Abbey case, which I'll show you briefly before I close. It's not clear what meaning of the word management the Crown contend for in suggesting that there is this ghostly aid, perhaps to construction, operating 13BD3. Management can have broadly 2 meanings. One is day-to-day management. I'll show you the list in Abbey in just a few seconds, which is dealing with the paperwork, dealing with policy questions, who do we lend to this year, what's our interest rate going to be, all of those matters which fall short of a transaction. And it is that meaning of management that the court said applied to 13BD6, which is on page 578, management of special investment funds in the Abbey case. On the other hand, in 13BD5, transactions including negotiation excluding management ... in shares, in that area, the word management may well, subject to the fact, of course, it's excluded, have or be likely to include transactional management, actually buying and selling. In 1 and 2, my submission in that vein would be this. The granting and negotiation of credit and the management of credit would suggest that the transactional part of that exemption is contained in the words the granting and negotiation of credit, and the behind-the-scenes part, the non-transactional part, is contained in the words management of credit. So that would include policy matters, due diligence, who do we lend to, what are the criteria, how much money are we going to lend out to the market, and so forth. So even if none of my other points are persuasive, at the end of the day, my key point is, if management is being used in a non-transactional sense in 13BD1, then its ghostly force, if any, on 13BD3 should be the same, and it therefore doesn't cover the intensely transactional supplies that my clients make, because they're actually dealing with movements of money rather than policy decisions behind the scenes. So those are 4 or 5 reasons we say this point goes nowhere. Can I just turn to the Abbey case, which is physical tab 25. It's E page 1012. And I invite the court's attention to this case for a couple of reasons. One is, as it were, judicial technique, how the court approaches the question of identifying the policy underlying one of the 13BD type exemptions, and also to indicate what has been said about this slippery word, management. Let me encapsulate it, if I may, very briefly, the facts. The contest was between Abbey National and another concerning, or dealers in securities, concerning how far professional trustees and administrators' fees to them should bear VAT. So we're back to the familiar situation. So we are in the sphere of financial transactions. So that simplifies matters. And the debate concerned 13BD6. Inevitably, a lot was said about 13BD5. The conclusion was that much of what was done was management, but a little of it making sure that financial compliance occurred fell outside management and was simply taxable. So if I may invite the court to look at Advocate General Cocotte's comments, the court at 1016 sets out at paragraph 7 the provisions that it was looking at, and it sets the learned Advocate General sets out the questions at page 1020 at para 25. As you can see, each question is focused on the word management. And then at page 1025, para 58, the Advocate General focuses on the question. And she points out that the court has yet to comment on this. But she says at 62 on page 1026, speaking of findings or conclusions made by Advocate General Maduro in a different case, applying to 13BD3 and 5, she says at 63, I'm of the view that transactions must be distinct in character. I'm so sorry, at 62. It is questionable to what extent those findings of the court may, as proposed by Advocate General Juarez Maduro, be applied to the exemption for the management of common funds for the purposes of 13BD6, and what consequences follow for the services which the National Tribunal has to assess in the present case. And she points out, as between points 3 and 5 and point 6, she says at 65, the concept of management in point 6 is more general and is not related to specific operations. Corresponding operations are indeed certainly carried out in connection with the management of the common fund, but this is not mandatory. Precisely in the case of long-term investment strategies or certain kinds of funds, such as property funds, it is conceivable that for quite long periods of time the market is merely observed and no new investments are made, but even during such periods there are functions to be performed which are part of the management of the common fund. And at 66, as a concept which I commend to the court, if the exemption were restricted to activities that affect the composition of the portfolio, only a minor part of the activity of common funds would be exempt from that. The practical effect of Article 13BD6 of the 6th Directive would be called into question. Activities of other kinds, such as those at issue in the present case, in practice make up a substantial proportion of the operations which arise in the course of the management of a common fund. An excessively narrow understanding of the concept of management would also have the effect of making outsourcing of partial services unattractive and thus making an economically sensible division of labour more difficult. Just pausing, that is, I respectfully adopt that as underlying our submissions on the main issues. In other words, the Advocate General is saying to the court, think about the practical effects of what you're going to, or what you're being invited to do. Think about whether it will in fact make outsourcing unattractive or economically challenging. And I, with great respect, we've made these points already in terms of the impact of the earlier arguments, but the court can actually see that they have legal force and should form part of the process. And then at 70 on the Well, at 68, she looks at the purpose of the exemption, and obviously that's something the court will be thinking about in any event. At 70, she says, it should be observed here, however, that the concept of management does not have the same meaning in points 5 and 6. I break off the quote there. At 72, she says, by contrast, the concept of the management of the common fund under point 6 has a completely different meaning. The detail doesn't matter. What I invite the court to take away from these quotes is that each of the exemptions is its own mini world, if you like, and each exemption should be construed within its four corners, within that wider context of practicality. The court, this is my last comment, the court at 1040, agreeing, says at 59...
Sorry, the references again?
My Lord, it's page 1040.
Thank you.
Para 59.
Thank you.
And it's the court, just as it were, bringing those comments into land as part of the judgment. Speaking of 1386, that provision must therefore be interpreted in the light of the context in which it is used and of the aims and schemes of that directive, having particular regard to the underlying purpose of the exemption which it establishes. And that purpose is again referred to at 62. I won't read that aloud, but having concluded what the purpose of point 6 is, and that is to allow people who are not wealthy to have the benefits of collective investment, which wealthier people can buy individually, the court concludes at 63 that these matters are covered. Just before I finish, there's one thing I didn't do, which was to point to the specifics of what was at stake, and if I could just finally invite the court to turn back to page 1017, where at para 10 and para 12 there are, from a directive, and not necessarily from the contracts in play, sample lists of the sort of things which managers would have to do. It's page 1017. I'm most grateful.
Yes, thank you, Mr. Kodara. Now, Ms. McCarthy, are we hearing first from you or from Mr. Ripley?
My Lord, I'll be presenting the Commissioner's case. Before I start, please can I ask if the court has received the two electronic documents that we emailed in this morning?
No.
We have hard copies if it's convenient to hand up a hard copy now.
It sounds as if you'd better.
Thank you. I'm very grateful. If I just explain what these are as they're being handed up. The first one is nothing more than a list of the cases concerning payments and transfers in chronological order, because it's useful to see, and
yes,
that is
helpful.
That is the order in which I can make my submissions on the case law. And the second is a case which, forgive me, it simply didn't make it into the bundle. It's AXA High Court. And that was the subject of quite a lot of discussion before the Court of Appeal, because it's part and parcel of the framework of where domestic courts went down the wrong route by following FDR before the reference to the Court of Appeal, to the CJU.
Has Mr. Kodara had notice of this?
Yes, and everyone on...
I mean, it was discussed by the Court of Appeal in this case?
It was the subject of a lot of oral submissions that I made to the Court of Appeal in this case. It didn't, I don't think, make it into the judgment. But of note, Mr. Justice Henderson, as he then was the judge in AXA, and he, of course, was one of the panel in the Court of Appeal, agreed with the Court of Appeal. So it's significant for that additional reason. So, my Lord, I'm going to take our written case as read, and I adopt those written submissions. In terms of my oral presentations, there are two high-level issues before the Court that I'll take in turn. One is target carrying out transactions concerning payments, transfers, debts. Two, if it is it nevertheless excluded from exemption because its single composite supply in fact amounts to either taxable debt collection or taxable management of credit by someone other than the grantor. Now,
I'm sorry, you were just a little bit fast there for me. Even if it does fall in the first part of 13b3, you say it's nevertheless excluded because it's either debt collection or
taxable management of credit by someone other than the grantor.
But I think there was a point you said, because it's part of a single composite supply, which is
it nevertheless excluded from exemption because the single composite supply that Target is making in fact amounts to taxable debt collection or taxable management of credit by someone other than the grantor?
So you're treating debt collection as a true exception?
I am, because that's what the CJU said very clearly in AXA paragraph 30 when we get to it. And I would add that it also doesn't necessarily matter on any view because the payments, transfers, debts argument is looking at one specific element, even if that specific element on its own terms might be exempt. The actual question for the court is to determine what is the nature of the overall composite supply. And so we have to stand back and look at everything that Target is doing, not just one little element that might amount to payments, transfers, debts. And then the payments, transfers, debts high-level issue itself has two limbs to it. First, what is meant by executing an order for transfer? And is it enough that Target triggered a process that automatically and inevitably resulted in payment? Now, we say no, that isn't enough, and I'll make that good by showing the court how the EU and domestic case law is developed on this issue chronologically. And I'll also deal with Target's new arguments on negotiation and this word potential that's arisen before the Supreme Court for the first time. The second limb of the payments, transfers, debts point concerns Target's loan account entries.
Sorry, the second one concerns?
Target's loan account entries.
Thank you.
Whether those changed the legal and financial situation. So that's the far narrower and briefer ATP point. And again, we say no, the entries don't make legal and financial changes. And just for your note, don't need to turn it up, the upper tribunal put it best at paragraph 83, PDF 234, when it said, the accounting entries in the loan accounts made by Target merely recorded the consequences of transfers which had taken effect elsewhere. And the Court of Appeal adopted that just for the transcript, Court of Appeal 104, PDF 211. Now, there is a preliminary matter which I do want to make submissions on first, and that is what role does Target play in all this? In particular, we say that Target is wrong to seek to align itself, to seek to align its role with that of SDC, FDR, and so on. It isn't performing that role. It isn't in that place
in the overall set of activities. It isn't performing a role in the, to quote, sphere of financial transactions in the sense meant by the cases. Now, SDC had delegated to it certain functions by banks who would otherwise have carried on payments and transfers themselves. But here, as you'll have seen from the decisions below, the borrowers have their own bank accounts. Shawbrook banks with NatWest and RBS. And in a couple of places in my learned friend's submissions, he referred to those as clearing banks, but I don't know why that is, because they're simply providing normal banking services to Shawbrook. Imagine Shawbrook's a greengrocer. That's the role that those two banks play here. Now, neither the borrowers' banks nor NatWest or RBS have outsourced their functions to Target. Rather, what's happened here is Shawbrook, as a lender, has outsourced certain lender functions to Target that it would otherwise have had to have performed in its role as lender. And critically, Shawbrook is not acting as a bank making payment or transfer supplies to its customers. And it's helpful, I think, if we can turn up what the Upper Tribunal and the Court of Appeal said about this, because they both agreed with that submission. So, Upper Tribunal, please can I ask you to turn up PDF 232. And please can I ask you just to read to yourselves paragraph 78. So, page 232, paragraph 78.
Yes.
And then the Court of Appeal makes the same point. Page 210, please. Can I ask you again, please, to read paragraph 99?
Yes, thank you.
And can I just put this another way, by reference to the terms of the exemption itself? And just for your note, I think my learned friend has been referring to the 6th directive, but when it comes to writing the judgment, it's actually the principle of that directive which is the relevant European legislation. So I'd rather look at that if we may, because all of the transactions here post-dated the entry into force of the PVD. So please, could we go to PDF 580? So it's 580, it's Article 135, and then we're interested in 1B and D, so bottom right-hand corner of 580. B, the granting and negotiation of credit and the management of credit by the person granting it, and D is the payments, transfers, debts provision. So can I make my submission in this respect about Target's role? In cases like SDC, the banks in those cases are making Section 135(1)(d) supplies to their customers. Those banks delegate some of that function to SDC. Question: are SDC's supplies within Section 135(1)(d)? What's going on here is Shawbrook is making 135(1)(b) supplies to its customer, to borrowers.
B. Yes.
So Shawbrook is supplying its borrowers with 1B supplies. It has delegated some of that function to Target. Question: are Target supplies within 135(1)(d)? We say, well, answer no. Why should they be? Also, Target supplies can't be exempt under 135(1)(b) because that is limited to the grantor, here Shawbrook. And if I may say, this shows the danger of taking the phrase sphere of financial transactions out of context. Not all financial transactions are intended to be exempt. For example, management of credit by someone other than the lender is taxable. And there are two particular features of this case that allow Target to disguise what I say is its sleight of hand. First of all, Shawbrook happens to be a bank, but that's not relevant in any material sense. Second, granting of credit happens to fall within the broadly termed finance exemption. Those two features together enable my learned friend to talk superficially about finance transactions, banking transactions. But it's important to recognise that fundamentally this case and Target's role is no different to Bookit or NEC or DPAS, where you have someone, so Odeon, the events organisers, dentists, Shawbrook, making non-135(1)(d) supplies to their customers. It has delegated the job of getting its receipts or income in. It's delegated to a subcontractor. Bookit, NEC, DPAS, Target. And as we saw yesterday, the simple act of enabling your customers to pay you is not a supply to them. And just for your note, that was everything everywhere at paragraph 28, PDF 1152. And the same point is made at Bookit, paragraph at 54, PDF 730.
I'm sorry, Ms. McCarthy, you're going a little bit fast for me. I'm not able to take the note.
So the point that I was making is, my learned friend showed the court yesterday, the mere act of enabling your customers to pay you isn't a supply to them.
For a theatre ticket or a cinema ticket or a filling or whatever.
Yes, exactly. And we saw that from Everything Everywhere PDF 1152, and well, it may actually be helpful if I can actually ask the court just to turn that up, please. So it's 1152, paragraph 28. Of Everything Everywhere. And if I could also just show you very briefly PDF 730, which is Book It, paragraph 54. And an identical paragraph coincidentally appears in NEC 49. We don't need to see that. Now, our submission, which becomes clearer when we go through the detail of these cases, is that Shawbrook is in fundamentally the same position. It's consideration, it's money that it, Shawbrook, wants Target to get in is the interest consideration for making a supply of lending. And the fact that it also needs to get the principal sum back that it lent to the borrower does not mean that it is making them a payment or transfer supply just by getting its money back.
So the loan is the service.
Exactly.
Or the giving of credit is the service. And that, if you treat it just like a pound of apples,
exactly.
The fact that you're getting in the payment by instalments, you say, is not a separate service.
Shawbrook is not providing its customers with any supply of payments transfers. It's not providing its customers with a 1351D service. So when it delegates some of what it is providing to its customers, that's very different to the banks in an SDC case, where the banks were providing a payments transfer supply, drop some of that down to SDC. Question, is that a payments transfer supply? The mere fact that that has been outsourced. Here, Shawbrook is not providing its customers with a payments or transfer supply. It's providing its customers with a credit, a lending supply. What's it dropping down to Target? Where's this payments and transfers piece come from in a world where that is not the supply that Shawbrook is making to borrowers? Just as Odeon wasn't making a payments or transfer supply to cinema goers. And we know that it can't be. See Everything Everywhere. So that's what I wanted to say about the role, just to set out very clearly up front our stall that it isn't doing the same thing as SDC. It isn't occupying the same place in a payments chain as SDC was. And I don't want to get drawn into backs quite yet, but we would say that SDC is occupying a role that is similar to something like BACS. So that central role, where BACS is the interface between payers bank BACS, Bank of England, who does the ultimate clearing or settlement, recipients bank. I'll come on to BACS later, but that, if you like, is the relevant financial sphere, and you can have interesting debates about whether certain subcontracted services by those actors may or may not be payments or transfer services. But Target isn't in that sphere. Target sits outside that. Target merely instructs BACS, equivalent to the Odeons of this world and NEC. And as I say, this will become clearer when we go through, but I wanted to make that point right up front. So that was what I wanted to say, first of all, about the role that Target plays. Now I want to move on to the first high-level issue, payments, transfers, debts, and what I called the first limb of that. What does it mean to execute an order for transfer? And this is the exercise of the chronological view of cases. So if we start with SDC, SDC is pretty much the only case where I'm going to make my submissions on some of the same paragraphs my learned friend has concentrated on because of its importance. So that was the date of that is June 1997. If I can start with a brief point about fiscal neutrality, picking up on my Lady Rose's question yesterday, and just for your note, that question is at transcript internal page 42. So that question centred on page 603, the Advocate General's opinion, paragraphs 52 onwards, and it's the section 52 through to 62. And Lady Rose put it this way, which I think is a very neat way of describing it. What these paragraphs are doing is describing the argument, if we did this ourselves, it would be exempt, and so if we subcontract it, it should also be exempt for fiscal neutrality reasons. But that argument is rejected by the Advocate General at paragraph 55 onwards. And if I could ask your Lordship, please, to read paragraph 57 to yourself. And I think the question was asked of my learned friend yesterday, did the court approve this? And my learned friend said no, but actually the answer is yes. So page 612, please. And the relevant paragraph is paragraph 28, if I could invite the court just to read that to itself, please.
Right, so if I decide to do my own ironing, there's no VAT related supply of that service. But if I pay someone to do the ironing, I have to pay them VAT.
So it's the point is, if a company asks its own employees to do something, that isn't a supply, because employees don't make supplies to employers. If a company subcontracts that, that is a supply, and the two aren't like for like, because one is a case of no supply and the other is the case of a supply which may be exempt or may be taxable. And I think the point is possibly most neatly expressed by the first-tier tribunal. If I could ask you please to turn...
There is a supply of that service done by the employees to the ultimate customer. It's
not of the service done by the employees. There may be a supply done by the company, but simply doing something yourself is not the same as subcontracting. And for that purposes, it'd be wrong to say, well, because I, the company, make exempt supplies, necessarily if I subcontract part of that, I must be receiving an exempt supply, because actually the two situations, you're not comparing like with like. And I think possibly the first tier expressed it most neatly. It's page 270, please. That's paragraph 108.
I'm conscious I'm asking a sort of Bateman cartoon sort of question, but apart from the fact that an employee isn't a taxable person, why is he not providing a supply?
Because he's not independent from the employer.
Why?
So
why is a contract of service radically different from a contract for services for VAT purposes?
Because supplies are centred on services between independent parties. An employee is not an independent party.
It's not an economic activity.
And it's not therefore an economic activity. And I think there is a definition. I don't off the top of my head have the directive reference, but it's built into the definition of taxable person and economic activity.
Really answer
So
that.
that isn't a point that's in dispute at all.
Yeah. No, I mean, no doubt it isn't, but it's, well, you're having raised a point with us. It's quite an interesting point.
I think we can double check this over the short adjournment, but we think it's Articles 2 and 9 of the Principal VAT Directive. I'm grateful to my...
2 and 9.
2 and 9. So Article 2, definition of taxable person or economic activity, and Article 9 is the definition of the other concept.
Which was the paragraph in the FTT's judgment you were taking?
Page 270, paragraph 108, which I think encapsulates the point most simply.
Yeah, here we are. Article 9 says taxable person shall mean any person who independently carries out in any place any economic activity. And then Article 10 says that the condition in Article 9 that the economic activity be conducted independently shall exclude employed and
Thank you.
other persons.
I'm grateful.
So it's express exclusion.
Yeah, I didn't have that quite at the top of my mind. So that's the submission I wanted to make about neutrality. No part of our submission offends against neutrality because it's simply not comparing two like situations. What I now want to do is turn to the core paragraphs of SDC and make my submissions on why we say the central part of Target's case is based on a misreading of SDC. Now, to start off with, please could I ask you to go to page 611. Yesterday, my learned friend looked at the language of the exemption and said that it was the word concerning in the phrase transactions concerning payments, etc., that was, as he put it, the true epicentre of the debate. And there were suggestions that made the exemption potentially broader. And his submission on that was transcript page 12. But as you can see from paragraph 22 of the CJEU at 611, that's wrong, and the court rejects an interpretation that's exclusively textual. Now, if I could please move on to the core paragraphs, which, first of all, CJEU paragraph 53, page 615, and in particular, it's 53 and 66 that the subsequent cases keep on coming back to try and interpret the words. So 53 includes the phrase, a transfer is a transaction consisting of the execution of an order for the transfer of a sum of money.
Is that this the first time that phrase, the execution of the transfer of a sum of money, is used?
It is, because SDC is the first case that starts all this off. It's characterised in particular by the fact that it involves a change in the legal and financial situation existing between, and then the court sets out certain relationships, and I'll come back to that in a moment. And this, moreover, the transaction which produces this change is solely the transfer of funds between accounts, so on. So, starting off then first with execution, we say that the court is making it clear here that the fundamental characteristic of an exempt payment or transfer is the execution of an order for the transfer of a sum of money. Nowhere in SDC itself does the court say that merely giving an instruction or an order or a request to someone else to execute is an exempt supply. So nowhere in SDC does the court say that some prior step to execution is an exempt supply. And what we will see is that all the later cases of the Court of Justice reinforce the fact that actually any such prior step is taxable. So SDC is not the basis for any such proposition about instructing, authorising, triggering. Next, changes in the legal and financial situation. At paragraph 53, the court summarises some of the changes in the legal and financial situation that might take place. So, starting off, and there are four, person giving the order and the recipient. So, between payer and payee. I'll come back to that relationship in a moment. Next, between those parties and their respective banks, so between payer and payer's bank, and payee and payee's bank, those are done by the respective banks. So the change in the legal and financial situation between the payer and its own bank is done by its bank. Likewise, between the payee and the payee's bank is done by its bank. Then the court contemplates, in some cases, between banks. So that's looking at changes in the legal and financial situation between payer's bank and payees bank. And certainly so far as the UK is concerned, that will be done by the Bank of England and or BACS, which is a clearing system. And those two entities affect those changes essentially by the processes of netting off in the case of BACS and of settlement in the case of the Bank of England.
But where it says the first one, between the person giving the order and the recipient,
Yeah.
the recipient of what, though?
So the
The
recipient of
your everything everywhere point, that actually just facilitating somebody to pay you for the bag of apples isn't actually.
So there will be a change in the legal and financial situation between myself and the greengrocer, sticking with apples. But how is that affected, and who is it that is executing that? Most of the time, nobody will be responsible for executing that as a standalone supply. Because in the situation that I've just discussed, the payer and payee relationship is changed because of the three separate stages. So it's a combination of, if I pay for a bag of apples electronically, I no longer owe the greengrocer, not because anybody has changed that legal and financial situation in a single step, but because my bank has made me a supply, the greengrocer's bank has made it a supply, and the Bank of England and possibly BACS have made supplies to those two banks.
It may be important to bear in mind that the subject of the sentence, it involves a change, is the execution of the order.
Yes.
Not the order itself.
So I no longer owe the greengrocer any money because of the changes that have been executed by my bank, BACS, the Bank of England, and the greengrocer's bank. Holistically.
It'd be helpful, actually, if you were able to tell us, in my mental picture of the role of how clearing operates and the role of the Bank of England and so on is based on what used to happen in relation to checks. What happens, how does it actually operate nowadays?
So if I can set out essentially what we say the role of BACS is, and critically, we don't say it's exempt because of any messaging function it does. We say it's exempt because of its netting off, so its clearing function. So
which, but you accept that that's under 1351D?
because in effect what it's doing is an ATP type role. It's clearing, so it's netting off, it's settling.
Well, is it BACS that clears, and or is it the Bank of England that clears?
So, if I can just start off with BACS, Banker's Automated Clearing System, HMRC accepts that it's exempt. That's because it's part of the clearing system. And the role that it does is it aggregates transactions from various banks and so let's assume that at the end of that aggregation process, one bank owes 150 and another bank is owed 100. BACS then will perform that netting off function. So BACS changes the legal and financial relationship because it will say, you no longer owe 150, you only owe 50. You no longer are owed 100, you're clear. I think I've got that slightly the wrong way around, but you follow that. So BAC's role is aggregating and then netting off. Now, at the end of that process, you've got a 50 that's owed by one bank to another. That is settled even higher up the chain by the Bank of England, and that's then cleared off. So the banks will be making, or will be changing, the legal and financial relations as between them and their account holders. So if I pay someone £50, I've got £100 in my account, my bank owes me 100 because it's got my money. If I want to pay someone, my bank has altered the legal and financial relationship as between me and it, because now I'm not owed 100 by my bank, I'm only owed 50 because 50 has gone elsewhere. So that is a legal and financial relationship which my bank alters. My bank will have many other customers like me, so will the other banks. Rather than all of these transfers going over individually, it's one step up to BACS. BACS will aggregate all the pro and cons, and it will work out, right, NatWest owes Barclays 150, Barclays owes NatWest 100. It will then change that legal and financial position by saying, right, that's no longer the case. NatWest now owes only 50 to Barclays. Barclays, you're clear. What happens with that 50? The Bank of England has money deposits from all the various banks, so it will say, NatWest, you owe Barclays 50. NatWest, as regards the account you hold with us, the Bank of England, you're now down 50, Barclays, you're now up 50. And so the Bank of England also changes the legal and financial relation.
And in your example where you're transferring, say, £50 from your account with Barclays to my account with NatWest, does BACS get involved in that?
It depends, but it depends on how precisely you do that. So if you make a BACS transfer, yes. If you were to make a CHAPS or a faster payment transfer, CHAPS is a separate system, faster payment is a separate system. Without going into the breathtaking detail, they do equivalent-ish roles to BACS, with the Bank of England always sitting at the top.
And how is that all paid for? Who does BACS charge for this service?
So BACS will charge its member banks. So in our case, in my example I've just been giving about NatWest and Barclays, NatWest is a member bank, Barclays is a member bank. They pay BACS for that facility. I have to say I'm not quite sure what happens with the Bank of England and whether that's paid.
And how often does the aggregating take place? Is it daily or? Again,
it depends, depending on what the service is. I think with BACS it's daily. I think. I might need to check that if it matters.
No, that's very helpful, thank you.
Thank you. And so, just to recap, because it is confusing, but at the same time it does help show that Target is no part of any of this. The legal and financial relationships, so just do it using my tiered system. I want to make a payment to someone. I owe someone some money. There's obviously a legal and financial relationship there between me and the person I owe money to. How that is done is not by somebody swooping in and saying, we're going to do one simple execution, there you're done. That's done by a process of the service my bank provides to me, and which quite often I wouldn't pay for because it's just part and parcel of my current account that I might hold. So my bank changes what I owe it. The person who I owe the money to, its bank changes what it owes that person. Step up one level to BACS. BACS does the altering of the legal and financial position in terms of aggregating and netting off. Step up one further level to the Bank of England if the result of the difference at the end of the day between the two banks means that money has to pass one way. The Bank of England will alter its legal and financial relation that it has with each of the banks. Now, that we say is the sphere of financial services in the way that the court is talking about. And the entirety of that process, if I can put this very loosely and precisely, money going up to the Bank of England from me and down to the other party, that whole process, the outcome of that is I no longer owe money to the other person. But that's not because somebody has come along and magically waved a single wand. That's the outcome of all those executions in the chain. Now, there's a separate case, which is ATP. It is possible that depending on the circumstances, you might be in a situation where someone like ATP has a completely separate set of books that deals with me and the person who owes me money, and it making an entry in its books has the effect of settling that. But that's the ATP argument that I'll come on to. That is not part and parcel of the money movements, broadly speaking, if you use BACS. That is something completely separate, which is, and my learned friend either wins or loses on ATP as a separate piece.
It was a pension book, effectively.
Yes, exactly. And the court's summary of ATP yesterday during my learned friend's argument was exactly right. And you can see in that case how actually somebody is keeping a separate account, which with one swipe of the pen has the effect of changing the bottom legal and financial relationship between two individuals, or in that case, employers and employees. But that isn't part of the BACS chain argument. That's something separate to the side.
The court in ATP gave two other examples of situations in which a book transfer would affect the change in the relationship, and one of those was where two bank accounts are held with the same person. And that was the position in MOM, where the two German banks both had accounts at Barclays.
Yes, and what I couldn't tell you, well, clearly in MOM, that was simply a question of the bank at the bottom end making an adjustment in its books. These days, that would actually probably have to be the chain up to BACS, the aggregation up to the Bank of England and back down, because it's not as simple as, the bank taking out a pen and making change.
Thank you.
And it may also be the same case with the current and the savings account, which was the other example that was given. I have a current account, I want to move money to a savings account. I suspect these days it may have to go through the entire chain. Previously, that may have been done by...
Because it's simpler just to deal with every transaction in the identical way, even if it turns out it's both transactions with the same bank, rather than have something that works out whether it's...
It's simply the electronic system that's now set up, whereas previously a banker would have written two entries in a book. These days, the electronic system is up to the top and down again.
Can I just check, because I've understood what you described as the tiered effect of BACS and the Bank of England. As I understand it, you say the BACS system operates to aggregate sums due between respective banks. So once that aggregation has taken place, that establishes the resultant debt owed by one bank to another bank.
Yes.
And one then goes to the Bank of England for the transaction which satisfies that debt.
So sorry, I think in saying yes, I may have elided two things. BACS will do the aggregation.
Yeah.
If NatWest owes 150 and Barclays owes 100, BACS will also change that so that now NatWest just owes 50.
Yes, that's what I meant by the resultant debt. It starts off
done
with
by BACS.
two things owed in different directions, in effect.
Exactly. And the BACS cancels those both out,
Right.
set off, and
So leaves
you're left with the balance.
the two banks with a new debt relationship between themselves in a different sum. And then as I understood your explanation of the involvement of the Bank of England, in effect, has a transaction which reflects that new debt in its bank account. Oh, sorry, the two banks' bank accounts with the Bank of England.
So as I understand it, NatWest will have millions and millions of pounds deposited at the Bank of England, as will Barclays. And what the Bank of England does is say, right, NatWest, you owe 50 to Barclays, that's the net result. Knock 50 off you, add 50 to Barclays.
So the Bank of England is doing, if you like, its own setting off.
Exactly.
Supplementing what has already happened in earlier in BACS in the process.
And so the point that I want to stress now that we've got into BACS, it was asked yesterday, what's HMRC's position on exemption? I hope you can see from my description of what we understand BACS does. BACS is exempt because it performs that netting off, that aggregation and netting off process. Nothing to do with its messaging side. And
it's aggregating and netting off, and thereby changing the legal
and financial. Exactly. So BACS,
you said nothing to do with.
It's messaging. So BACS can send as many electronic messages as it likes. We're not interested in that. The critical thing that BACS does, it's a clearing system, is the clearing function of the aggregation and the netting off. So that is why HMRC is content to exempt BACS. And I'd also make another point at this juncture. You may have seen from the Eagle investment case and from MOM, quite when debts are said to be settled depends on the terms of the contractual relationships between the various financial institutions. Now, back in the day, I understand, somebody at HMRC will have looked at all those BACS contracts. We don't have them now. We haven't looked at them recently. But it will have been as a result of that exercise that was the conclusion reached. That is why we understand BACS is properly exempt, because that is what we understand the function to be. And I make the other point, if it turns out that in 2023 those contracts no longer say that, then obviously maybe we have to look at BACS again. But that's our understanding, and
what's your understanding of the policy reason why that should be exempt?
Well, there isn't a policy reason as such. It's simply the legal analysis of the overall.
Yeah, no, I'm not saying it's a policy that HMRC had adopted, but does HMRC understand, can you tell us, why the EU legislature decided that that kind of transaction should not bear VAT?
I think the short answer is no. It may possibly be to do with the fee charging structure, because what I can't tell you now is exactly how BACS is paid. And obviously, if the Bank of England may or may not be paid, because the Bank of England is in the position of having all the deposits of money, so it may simply take its fee, so to speak, by the fact that it's got the money.
Uses the money to make more money.
Exactly. But the reason why, at the bottom end, if my bank were to charge me, the reason why retail banking isn't charged, isn't subject to VAT, one of the main reasons, is how exactly do you work out the consideration? I have deposited £100 with NatWest in a current account, so NatWest has use of my money. I'm getting paid practically nothing by way of interest. NatWest will also help me pay my greengrocer. So, in a sense, I'm providing a money lending service to NatWest by giving it £100, but it's providing me with transaction services and all sorts of other things. How do you even begin to work out the consideration? This is the point that is made in Velvet in Steel. It's just too complicated to start taxing those transactions, because you can't even really work out what the supplies are, what the consideration is for those supplies. So that's the point about ease that the Court of Justice mentioned in Velvet and Steel. So we've sidetracked a little bit, but that is a discussion that I wanted to have at some point. So I'm glad we've covered that off early. So that is what paragraph 53 in the CJU decision in SDC is really getting at, and that is how those relationships work. And just pausing there, you can see now that when Target on the outside issues an instruction into that loop or into that stepping up pyramid structure, Target is just an outsider. Target isn't part and parcel of the various entities responsible for changing the relevant legal and financial situations. All it does is kick it off. Because what Target is doing is, rather than me saying to my bank, I want to pay Shawbrook, please, Target is giving that instruction because I filled out a direct debit mandate.
So what do you say about paragraph 54, which Mr. Kulara relied upon? About how a data handler may come within the exemption.
So I think, and it may be that I need to come back to this, I hadn't intended to discuss 54, but I think 54 is talking about SDC's customer, which is something different. It's not talking about a bank's customer, the man on the street.
You think SDC is a data handling centre?
Well, that's its description. SDC has been described as a data handling centre by the CJEU. So I'm simply adopting what the CJEU tells us SDC is. Now, if I can move on, please, to the discussion of transfers and payments, which is from paragraph 61 onwards, PDF 616. And this next piece is important because it sets out the competing arguments between Denmark and SDC. So 62 summarises Denmark's argument. And in effect, Denmark was saying, the Danish ministry was saying, that SDC's services couldn't be exempt because they were invoiced in their various administrative or technical components. So that's quite an extreme argument. We don't care what SDC is actually doing holistically. Exemption should be denied because of the manner of invoicing, because the invoicing split up SDC's various elements into things that on the face of the invoices looked technical and administrative. Now, on the other hand, paragraph 63 summarises SDC's argument, which is at the other end of the spectrum. And 63 is important because SDC was saying that it's sufficient for exemption that SDC merely supplies one element of a financial service, where that, when combined with the supplies of others in aggregate, constitutes a complete financial service. So SDC is saying it's enough if we do a prior step, if when combined with the actions of another, the end result is the execution of a transfer. And that, in effect, is what Target's argument is between this court. Target is saying, well, our services should be exempt, provided that the end result is payment or transfer, when aggregated with what BACS does and what the banks do. And so moving on to 64, 64 is directed only at Denmark's argument about invoicing. So Article 13BD 3 doesn't in principle preclude a transfer from being broken down into separate services, which then constitute transactions concerning transfers, and which are invoiced by specifying the elements of those services. So 64 is all about Denmark's quite extreme invoicing argument.
So the invoicing argument is in effect form over substance,
Yes.
Is that right?
Yeah, exactly.
Just how
It's
they
nothing.
happen to write in
Yes.
the invoice
Yeah.
to describe it.
But nothing in 64 can support Target's proposition that different suppliers can supply different elements, such that suppliers involved in a step prior to execution must necessarily be making an exempt supply when that execution is carried on by someone else.
But just going back to your earlier Barclays, NatWest up to Backs up to the Bank of England, do you say that each of those changes of relationships that we've been talking about is itself an execution of the transfer, or is the whole thing one execution?
Each of those changes is an execution of a transfer, potentially performed by different people. So you've got the banks at the bottom doing one part, Backs in the middle doing another part, Bank of England at the top doing a third part.
So each of those steps is a separate execution?
Is a separate execution, is a separate payment and transfer service, because each step is effecting a change in the legal and financial relationship between someone or other. And so each of those is its own self-contained supply. Now, 65 is important because 65 is expressly rejecting SDC's argument at 63. So SDC has said, well, if we do a prior step and someone else executes, that's the effect of SDC's argument at 63, that should be enough, shouldn't it? Because we SDC are essential in getting the whole thing done. Court of Justice says at 65, point 3 must be interpreted strictly. The mere fact that a constituent element is essential for completing an exempt transaction does not warrant the conclusion that the service which that element represents is exempt. The interpretation put forward by SDC, i.e. at paragraph 63, cannot therefore be accepted. And just to note, essential, the mere fact that a constituent element is essential here means essential in the sense of indispensable or necessary. And we see that when we don't have them in the bundle, but the Court of Appeal touched on this point when you look at the different language versions. And the reason I'm pointing that out now is because the word essential crops up again later, talking about specific essential functions. In every other language version, other than English, a different word is used in 65 to 66, and the word used in 65 is of the nature of essential. We see that from the English language version in NEC, because NEC talks about essential here meaning indispensable, necessary. And the Court of Appeal picks this up in its judgment.
Different language versions of what? Of this judgment?
Yes.
Right.
Yes.
And just for our notes, can you give us the Court of Appeal paragraph number? If you
Please,
can't,
can I
don't
come
worry.
back to that?
Yes,
it's later in my submissions. I don't have it off the top of my head, I'm afraid. So pausing there, 65 could not be clearer in rejecting, in effect, the argument that Target is making in this case, namely its services should be exempt because they are necessary precursors to a transfer executed by someone else. Because that was what SDC was arguing in the 63. Court of Justice says no at 65.
So in effect, the reasoning seems to be because you adopt a strict interpretation of the exemption, you zero down on the transfer itself, not acts preparatory to the transfer or anything else.
Yes, yes. And we see in the later cases, acts preparatory, acts that trigger, even if that triggering and the chain is then automatic, are not enough. And now, CJU 66, the court here makes it clear that for a supply to be exempt, it must form a distinct whole, and that distinct whole must fulfill the transfer of funds and changes in the legal and financial situation. So the distinct whole must be actual execution. That's how we interpret 66. And so in order to be characterised as exempt transactions, the services provided by a data handling centre must, viewed broadly, form a distinct whole, fulfilling in effect the specific essential functions of a service described in those 2 points. And this second word, in every language version other than English, essential here is different to the word essential in 65. And in NEC, 65 actually uses the word indispensable, and 66 then uses the word essential. And I'm grateful to my learned junior. It's Court of Appeal paragraph 50, page 193, where the Court of Appeal notes that.
Yes, thank you.
And so for a transaction concerning transfers, the services provided, I'm reading from 66. I'm sorry.
You would still say that the distinct whole, I think this is what's been confusing me, because I thought when it was referring to the distinct whole, it meant all those steps combined. But you say, I think, that the distinct whole is still that little bit, each of the little bits between the in that chain that we were talking about is of itself a distinct whole, even though it's not actually comprised of different elements once you break it down to...
But each of those pieces is a whole in the sense that each of those pieces performs a legal and financial change.
Yes.
And each of those pieces is done by someone different. So there is no single entity standing over everything that is responsible for all the way up to the Bank of England and back down. Rather, that system is probably comprised of four separate changes in the legal and financial situation. Between each bank, so 2 at the bottom, the backs change, the Bank of England change. So they're 4 separate transfers, 4 separate executions, but the point is that each of those changes is itself a change in the legal financial situation between someone in that picture, someone in that sphere. And so what BACS does forms a distinct whole, fulfilling in effect the specific essential function, so the core fundamental function of a service, because it is changing the legal and financial relationship vis-à-vis 2 banks, and so on. But what isn't enough is for Target to come along and say, well, okay, I don't do what BACS does, but BACS doesn't do anything at all unless I give the instruction. So therefore, the giving of the instruction that starts that automated process, that must be necessarily included. And Court of Justice rejects that specifically at 65. And what's being said at 66, no, you have to perform one of those changes in the legal and financial situation. So BACS performs a change vis-à-vis the 2 banks. If you perform one of those changes, you're in. So if what you do that forms a distinct whole fulfills that function of performing a change, then you're in. And so what Target does doesn't do that, because it isn't responsible. Park the ATP argument. In the messaging argument, it isn't responsible for making any of those changes that we've just been discussing.
So in the last sentence, when it talks about extending to the specific essential aspects, that's a reference back, is it, to the distinct whole part?
Yes, so I'll pick it up a little higher up. For a transaction concerning transfers, the services provided must therefore have the effect of transferring funds and entail changes in the legal and financial situation. So, for example, that's what BACS does, because it has that effect and it entails changes vis-à-vis the two banks at that level. An exempt service must be distinguished from merely physical or technical, such as making a data handling system available to a bank. And then this is the sentence. In this regard, the Court of Justice did not actually say SDC is exempt. It sent it back to the National Court. The National Court must examine in particular the extent of the data handling's responsibility vis-à-vis the banks. Parking there, so are you a data handling centre that's doing the BACS role? In particular, the question whether its responsibility is restricted to technical aspects or whether it extends to the specific essential aspects of the transactions. And we would say BACS does extend to the specific essential features, essential aspects, because its responsibility extends to actually making a legal and financial change between the two banks. So BACS tick, yes, because that is what that last sentence means. Is it actually making the legal and financial change? That is the specific and essential in the sense of the core fundamental central aspect.
I read the reference there to the mere physical or technical supply to be excluding the telephone system or the software program that does it. That's, in a way, that is what's affecting it, but you exclude that as being simply the technical, administrative way it's done.
So they're the easy and obvious ones. And of course, SDC was not concerned with somebody that isn't in the position of BACS, but might actually at a prior step speak to BACS, instruct BACS, trigger it. So SDC may have used the looser language because it's not actually trying to distinguish a particular prior step, because that's not the fact of the case before it. That complication comes up very clearly in the later cases, and then the Court of Justice says very clearly, no, if you're an instructor, that's not enough. So I entirely accept that the very obvious low-hanging fruit that is being rejected by 66 as being taxable is telephone. Are you providing a computer system? But the question in SDC was not about triggering or instructing at all. And now that we've seen the core pieces, nothing in those core paragraphs underpin, triggering, instructing necessarily must be exempt, because SDC is simply not dealing with that at all. And so it can't be ruling on something that isn't before it. And so, my Lord, just to come back to your question, what are the specific and essential aspects? They, we say, are the aspects summarised in CJEU para 53, so execution of an order for transfer involving a change in the legal and financial situation. And so once SDC is properly understood, we say it's clear that it doesn't support the central aspects of Target's case. So, and if I can take these in turn, SDC does not say anywhere that data handling or being a data handling centre of itself is sufficient. It does not say anywhere that causing money to move by sending or receiving messages along a chain is sufficient. SDC says nowhere that writing or originating messages is sufficient. To the contrary, if actual execution is carried out by another supplier, only that supplier is exempt, and not a prior step, even if it is indispensable. And that was the Court of Justice rejecting SDC's argument that I showed you a couple of moments ago. Target relies very heavily on the fact of SDC being in an intermediary role, but nothing in SDC says that that is sufficient of itself. Rather, what you've got to focus on is the function performed by the intermediary. It's the function that is determinative. And as I've already said right at the start, Target isn't an intermediary of the banks. It's not an intermediary of BACS. It's not an intermediary of the Bank of England. It's outside that. Its role is an intermediary of a moneylender, which just so happens to be a bank. But as we've already seen, Shawbrook itself uses other banks to actually deal with its payments and transfers. Target has also relied on the necessity of a supply, i.e. it is doing something that Shawbrook would otherwise have to do to effect payment. But SDC 65 specifically tells us that because an element is essential in the sense of indispensable, that does not make it the supply exempt. And we say that Target has mischaracterised 64 of SDC in suggesting that the CJU somehow acknowledges that the execution can be broken down into separate steps, each attracting the exemption. But we say that's wrong when you read 63 and 65 together, because that was the core of SDC's argument that the Court of Justice rejected, 63 and 65. And so, pausing there, that's the end of SDC. What I would say about SDC is nothing that emanates from that directly supports Target's theory. The best that can be said, as demonstrated, it's very dense and it's potentially unclear in places. Now, that lack of clarity is clarified in the later judgments, but nothing that the Court of Justice has said in SDC must mean that it wins. So in the Court of Appeal dismissing Target's appeal, necessarily the Court of Appeal here is not doing anything at all that interferes with SDC, because SDC does not say what Target needs it to say. Next in the chronology that I want to go to is FDR Court of Appeal, please. And that starts off at PDF 855. Now, if I can just take this at a high level to start off with, please. There are two issues in FDR that are relevant to this appeal. First of all, did FDR make transfers by means of its use of the BACS system? Secondly, did FDR make transfers by means of a netting off process? I'm going to park FDR's netting off until later because that relates to the ATP argument. I'm focusing for the moment on FDR's use of BACS. So if I could ask you please to go first of all to page 869. And please, could I ask... Actually, I'd like to start off with paragraph 34. I don't need to trouble the court reading the whole thing at the moment. So paragraph 34 of FDR 869. Mr. Paynes, who was HMRC's counsel before the Court of Appeal, was arguing that transfer is constituted by the execution of an instruction and never merely by the instruction itself. And the Court of Appeal quotes a passage from HMRC's skeleton in that case, In that case, HMRC was arguing that the distinction drawn by the ECJ in paragraphs 65 and 66 is between a service which is indispensable, which is insufficient, and a service which itself contains the essential elements of an exempt supply, and thus is an exempt supply. And HMRC were arguing that it's only the latter that qualifies for exemption. And then skipping down just to the first part of 35, the Court of Appeal says, in general terms, I agree with this.
So Mr. Paynes was making the same argument that you're making.
Yes.
Yeah.
And in general terms, the Court of Appeal and FDR agreed with that. There's a short analysis, if we can please move forward. And I should say the rest of 35, all that is being said there is, but I must look carefully at what FDR actually does. So if we could move forward, please, to PDF 871. And there's very short reasoning of the Court of Appeal in relation to the BACS aspect at 40 through to 42. And 42 is the important piece. Here, Lord Justice Laws considered that there was a different outcome in relation to the BACS element, since the issue of the instructions by FDR to BACS triggered a process that automatically and inevitably resulted in payment, and so it therefore fell within the exemption. So Lord Justice Laws was content to agree with HMRC's general submission, but the critical piece is at 42, where his lordship is saying, but actually, if you are triggering that process, and importantly, that process once triggered is automatic and inevitable, then being the body that fires the starting gun, if you like, must be sufficient. And you can see this from the rest of the discussion in 42. And so the critical part of the Court of Appeal's reasoning turns on the automatic and inevitable nature of the BACS process once the instruction has been delivered. And we'll see in due course when we get on to Nordia Pankey, Bucket, NEC, that feature, an automatic and inevitable process triggered by someone firing the starting gun, is not enough to qualify for exemption. So this is where we say that the Court of Appeal goes wrong. I'll come back to netting off when I deal with the ATP point, but that's all I wanted to say on FDR. Next in the chronology, I'm going to pass over for the moment the CSC case, because that I'll come back to in due course, because it knocks on the head my learned friend's negotiation argument as to why that's wrong. But it doesn't add much to what is said in SDC. In the interest of time, I'm also going to move over EDS Court of Appeal in 2003. All I want to say on that is we don't consider it adds anything to the debate that instructing BACS is insufficient. It actually is decided on its own facts, which on any view are different to targets for the reasons pointed out by each of the lower courts and tribunals in this case. And so I would simply refer the court to those decisions on that point. Now, next in the chain, there's Bucket 1 in the Court of Appeal, and that is 2006. And so I'm just following through my chronology. I don't need to turn it up because there's a good discussion of what the Court of Appeal decided in a later case, so I'll simply refer to that in due course. But all I want to say about Bucket 1 is it's materially indistinguishable from Bucket 2, fact-wise. No reference was made. All that the Court of Appeal did in Bucket 1 is it applied the FDR BACS analysis, and it held that Bucket supplies must be exempt, because Bucket likewise gave instructions, I think in this case to Gyrobank, but which triggered a process that resulted automatically and inevitably in payment. So that is simply the application of FDR to Gyrobank. Next comes, and this is important, AXA in the High Court in May 2008. And this is the case that I handed up and should also be potentially over the short adjournment coming to you electronically. And as I mentioned, this was the subject of quite a few of my oral submissions before the Court of Appeal. You'll note that the judge hearing this case, so AXA High Court in 2008, was Mr. Justice Henderson, as he then was. Now, he determined that Denplan was making multiple supplies, some were taxable and others were exempt payments and transfers, and so there therefore needed to be some sort of apportionment. If I could ask you please to turn over to the held note and just look between little c and little e. And what we see here is the court's finding in relation to Denplan's use of BACS was that BACS was automatic. It did as it was told. Where payment was made by that method, it was an automatic result of the instructions given by Denplan. When it was allowed to perform that function without interruption, the inevitable result was a change in the legal and financial situation. So this reflected the reasoning in FDR and Bucket 1 about triggering a process which automatically and inevitably results in someone else someone else executing the order. The person doing the triggering is exempt. And you'll see that the way it's described here, whether the service in question had the effect of transferring funds was seen as a question of causation. Just going through the key parts of the judgment, please. If we can start with paragraph 23. That sets out the relevant part in FDR that we've just seen. That's paragraph 23. If I could then move forward to paragraphs 36 and 37. So at 36, the High Court is quoting from paragraph 42 of FDR, which we've just seen. And at 37, there's a summary of how the tribunal in AXA addressed the BACS point in the light of FDR Court of Appeal. So BACS automatically carried out the instruction, and so by giving the instruction, FDR was effectively executing the order itself. Then Mr. Justice Henderson says, I agree. Skipping down a couple of lines, what matters is that BACS is a purely automatic agency, and where it performs its function without interruption, the inevitable outcome will be a redistribution and therefore a transfer. The essential point, as I understand it, is that BACS is a system which simply does as it's told and makes no independent input. Therefore, a person who uses BACS makes a transfer no less than a person who makes a payment in a different way. So again, this automated feature of BACS is key. What then happens is from 41 onwards, there's a discussion of Bucket Court of Appeal. And if I could move forward to 44, Lord Justice Chadwick was the judge giving leading judgment in Bucket Court of Appeal. The decision, the judgment at the High Court in AXA quotes from it at 44, just skipping some intervening words. The effect of the supply by Bucket was that the price of the ticket and the card handling fee was transferred. So what it's looking at is the effect of the supply in terms of the end result, if you like. 47 to 49 sets out how AXA, the first tier tribunal in AXA, analysed and dealt with FDR and with Bucket. And if I could ask you, please, just to read 47 through to 49. And 49 in particular is important because that sets out what the then first tier tribunal thought the authorities, including FDR and Bucket 1 Court of Appeal, was finding. So that is what the the first tier tribunal in AXA saw those UK cases as doing. I can then skip forward to paragraphs 51 and 52, because this now sets out why HMRC said it was wrong. So 51, the question in this appeal is whether or not calling for money on behalf of another, pursuant to a direct debit mandate, constitutes the provision of a service which has the effect of transferring funds. And then at A, HMRC was saying the calling for funds under a direct debit mandate doesn't itself effect a transfer. And 52, accordingly, it was submitted by HMRC, the making of the request does not effect a transfer of funds. Any transfer which takes place in response to the request is effected by entities carrying out functions within the banking system, as well as any companies to which those parties have subcontracted specific elements. And that approach was rejected by the High Court. And you can see the High Court's conclusion starts at paragraph 69. And if I can pick it up, the key paragraphs are 71 through to 75. So at 71, just the first sentence, it's important to remember at this point that the exemption is not confined to transactions which themselves constitute the transfers or payments of money. And this is what the High Court is saying, bearing in mind FDR and Bucket 1. And then just the last 4 or 5 lines of 71, the question identified is whether the transaction carried out by the service provider has truly effected, in the sense of brought about a transfer. And then at 72, Bucket seems to me a good example of a case where the causal test was supplied and answered in the taxpayer's favour. Skipping on a couple of lines, what matters is that the information supplied by Bucket to Gyrobank inevitably brought about although it did not itself constitute a transfer of sums of money from Gyrobank to Bookit. Over the page, the person who actually made the transfer was Gyrobank, and a couple of lines down, nevertheless, Bookit effected the transfer because the information transferred by Bookit to Gyrobank was all that was needed to trigger the making of the transfer by Gyrobank to Bookit. 73 is a rejection of HMRC's position. 74 is repeating the point that was made in FDR, and just 3 lines down, the crucial point was that BACS is purely automatic in its operation and was merely the means by which FDR effected transfers. And so again, the High Court in AXA sees that as the critical reasoning in FDR. Then 75 is the key paragraph in the reasoning in AXA, and it's essentially the point that I showed the court right at the start from the head note. And as you can see, 75 between little f through to h, the central part of the reasoning was that in AXA by the High Court was that Denplan itself had no discretion in the matter once the instructions had been sent. And then this, in the circumstances, it seems to me clear that the causal test is satisfied in respect of all those cases, the vast majority where the direct debit payment is in fact made pursuant to the instruction given to BACS by Denplan. Then you have the point just by H, where payment is made by that method, it is made as an automatic result of the instructions given by Denplan. And pausing there, that's a clear summary of FDR and Bookit 1 Court of Appeal. All that the High Court is saying in AXA is simply triggering a process which has the end result of payment and which is automatic and inevitable is sufficient to represent an exempt payment and transfer service. And pausing there, that in a nutshell is correct.
Just in the middle of that F there,
Yes.
it says Denplan itself had no discretion in the matter once the instructions had been sent. Is that because Denplan was told by the dentist what it needed? I don't think the absence of its discretion on Denplan is the relevant.
Right now, I'm wondering if that should in fact say BACS.
Well, I was just wondering.
And actually, when I read it out, I did wonder, as I said to Denplan, whether in fact that should have said BACS. So I think for the time being, I think I might actually say that that's a typo and it should probably say BACS. But in a nutshell, what the High Court has decided in AXA is correct as far as the domestic cases at that time stood. Critically, of course, one of them is Bookit 1, and I keep emphasising Bookit 1 because we know that Bookit 2 was not materially distinguishable on the facts, and the CJEU said, no, you've got it all wrong. Triggering an automatic process is not enough. And in fact, as we'll see in Bookit 2, the court itself uses the language of triggering in a paragraph that my learned friend skipped over in his presentation yesterday. And it rejects that language, it rejects that function. Now, if I can proceed along the chronology, the next thing that occurs is the AXA Court of Appeal first hearing. There was a first hearing following which the reference was made. And if I can ask you, please, just to go briefly to PDF 928. And please can I ask the court just to read paragraph 2. So what this is the later judgment of AXA. There was no published judgment from AXA hearing 1 where the Court of Appeal made the decision to refer. All we've got is the summary at paragraph 2 as to what happened there. And so what we see from this summary is that as early as April 2009, which was when the first AXA Court of Appeal hearing took place, the Court of Appeal said, hang on a second, and I think the phrase used is addressing doubts. The first Court of Appeal hearing in AXA, the Court of Appeal had doubts as to the correctness of AXA High Court, and this notion of triggering, is triggering really enough? So it certainly isn't the case, as my learned friend would seek to suggest, that for the last 20 plus years everybody's been happy with the notion of triggering. Actually, in 2009, at a very early stage, after only FDR and Bucket, where there was no request for a reference, simply applying FDR, and now AXA 1, the Court of Appeal looking at this and thinking about it seriously says, well, actually, have we really got this right? And we can see what the Court of Appeal's doubts were when we look at the questions that it referred. Now, unfortunately, there is no published judgment containing those questions and the reason for the reference, because that would have been very useful background. But we can see the questions if we go to page 657, please. So at 657, we have the next step in the chronology, which is AXA Court of Justice, the hearing, which took place, and the judgment, which was handed down in October 2010. And if I can go through, the questions are set out at CJU 17. They are quite dense, so maybe if I can go through them in stages. So the thrust of question 1A is, if someone steps into the shoes of one of the banks responsible for debiting or crediting bank accounts, or of someone performing some sort of intervening task, so we say like BACS, is that exempt? So question 1 is not looking specifically at AXA, it's simply looking at the banks who do the debiting and crediting, or someone performing a task in the middle like BACS. What is the position if they subcontract? Question 1B is picking up on this notion of causation, which, as we've seen, played a big part in, as he then was, Mr. Justice Anderson's analysis. So is the exemption applicable to services which do not include the carrying out of tasks of making a debit and a corresponding credit, but which may, where a transfer of funds results, be seen as having been the cause of that transfer? So this is the point about triggering. Question 2 is very compressed. So if I could just ask the court to read question 2 for itself first of all, and I'll make some submissions on it briefly.
I mean, at the end of the day, as usual, the court didn't actually answer the questions put to it. So
No, it didn't. But the reason for showing this is so that you can see the doubts that Court of Appeal in AXA had, and that is important because you see that in due course, the same type of questions are then again referred when we get to Bucket and NEC. And so that's the reason for showing you this, to show you the chronology and the progression. And so question 2, in effect, is asking whether someone that sits outside the sphere of debiting and crediting bank accounts and outside the sphere of an intervening task is making an exempt supply by transmitting information or by giving an instruction to transfer funds. So this is the Court of Appeal in AXA saying, well, Denplan sits outside. Is that role nevertheless sufficient to be making an exempt supply? Where it transmits information and instructs the transfer of funds. And then question 3 Does it make a difference to question 2? And essentially, this is the point about triggering. If the relevant person triggers a chain which then automatically communicates with the relevant banks, as a result of which the payments are effected. And just to wrap up, because I think I'm over, but we can then move on from AXA after lunch. So these questions are asking the Court of Justice to choose between the two sides of the debate in the UK at this point. Is it enough that you simply fire the starting gun, i.e. like target, or do you actually have to be involved in the execution itself? In other words, like the banks or someone directly in the middle like BACS. And we know, of course, the Court of Justice went off on a different tangent, having first accepted in principle that the supply was exempt payment and transfer service, and that's why it said, well, now we need to carve it out because of debt collection. But I think this is a convenient moment to pause, so this is where we are in terms of the difficulties that the domestic courts are having with these cases.
Very well. We'll resume at 2 o'clock.